We received an email from Farrah Ricario. The subject of her email reads, "Filing of petition for annulment in the court abroad." According to Farrah, she wanted to know how they can speed up an annulment of marriage based on a cheating wife. She is asking what grounds they can use in order to annul a marriage. Farrah, it seems that you forgot to provide us a lot of pertinent details in your letter. First, you did not discuss if you are one of the parties in this issue. We noticed that you use the word "we" in your email. Remember that an annulment should not be based on the mere of both parties. Second, you wrote in your subject on your email that this is about a petition for annulment abroad. The nationality of the parties involved were not clear. It was also not provided where both parties reside. It is important to note that the filing of a petition for annulment of marriage should be filed in the place where one of the parties is residing for at least 6 months. We shall presume that both parties are Filipinos and that you just want to know the various grounds for annulment of marriage. You may base your grounds on Article 36 of the Family Code, more known as psychological incapacity, which states that the petition should allege the complete facts showing that either or both parties were psychologically incapacitated from complying with the essential marital obligations of marriages at the time of the celebration of the marriage, even if such incapacity becomes manifest only after its celebration. You may also base your grounds on Article 45 of the Family Code. The important aspect of the grounds enumerated under this provision is the fact that the petition for annulment must be filed within 5 years from the time of discovery of the following grounds. Otherwise, the same may no longer be filed based on Article 45 of the Family Code. First is the absence of parental consent. This ground means that a marriage was solemnized between parties and either one of both of them are between the ages of 18 to 21 years old when they entered into a marriage without the consent of their parents. If the parties still cohabited with each other for more than 5 years after attaining the age of 21 years old, the annulment may no longer be filed. Second ground is mental illness. If one of the parties was of unsound mind at the moment of marriage, but the other party still freely cohabited with the other after he or she has come to reason, he may no longer file the petition. The third ground is fraud. This means that the consent of one of the parties to the marriage was obtained through fraud. However, if the other party still freely cohabited with the other, despite discovery of such fraud, the petition for annulment may no longer be filed. Fourth, the consent of either party was obtained by force, intimidation, or undue influence, except when such has ceased and the filing the petition freely cohabited with the other as husband and wife. Fifth, one was physically incapable of consummating the marriage and such incapacity continues and appears to be incurable. And sixth, at the time of marriage, either party was afflicted with a sexually transmitted disease or STD, found to be serious and seems to be incurable. With regard to your last question, Farrah, proceedings for annulment of marriage are mandated by law and the rules of procedure. You can be assured that the court which will hear it will follow the procedures as prescribed by law. Be reminded that our opinion is based solely on the details you have provided us, and you are free to consult a lawyer of your choice regarding your legal concerns. Thank you for your trust in People's Television. Email us at ptv4newscenter@gmail.com. This is Attorney Jimeno Atienza for the Rule of Law.